5, 4, 3, 2, 1, start. Learned counsel for the petitioners has primarily emphasized that learned prescribed authority while rejecting the application moved by the petitioners for cross-examination of the witnesses produced by the plaintiffs has erred in law. He has also stated that while rejecting the application seeking permission to cross-examine the witnesses, the learned prescribed authority has not assigned any plausible reason. Therefore, his further submission is that a specific ground was taken by the petitioners by filing appeal before the appellate court against the order dated 22/12/2012 passed by the prescribed authority. That learned prescribed authority has wrongly rejected the application seeking opportunity to cross-examine the witnesses, but learned appellate court has also not considered the said prayer in its correct legal perspective. In this regard, he has submitted that application made by the petitioners before the appellate court was rejecting on 22/11/2024 with the observation that the issue will be considered by the appellate court at the time of final hearing of the matter. However, while rendering the final judgment, the appellate court has not considered the said prayer and has also not taken into account the ground raised by the petitioners related thereto by observing that the application made by the petitioners stood rejected earlier, and as such there is no justification in considering the said application stanza. Apart from the aforesaid ground of denial of opportunity to cross-examine the witnesses, learned counsel for the petitioners has also stated that in fact the finding of fact recorded by the learned prescribed authority, which has been affirmed by the appellate court in respect of bona fide need the comparative hardship, is also against the evidence available on record. The other hand, learned counsel representing the respondents has submitted that in the facts and circumstances of the case, no interference by this court is warranted in the judgment rendered by the prescribed authority, which has been affirmed by the appellate court. He has also stated that in absence of any provisions under UP Act No. 13 of 1972 permitting cross-examination of the witnesses, there is no legality which can be said to have been committed by the prescribed authority in denying the said opportunity to the petitioners. Stanza. Taking up the first argument raised by the learned counsel for the petitioners, I may only refer to the contents of the application made by the petitioners before the prescribed authority. The said application, it was submitted by the petitioner before the prescribed authority that under the changed circumstances the respondents have put wrong facts in respect of shop which is adjoining the premises in question and was earlier in the occupation of another tenant, Ram Raj Prajapati. It was further stated in the said application that earlier the learned prescribed authority had rejected the application for issuing commission, and as such it would be in the interest of justice that in respect of the fact deposed by the witnesses produced by the respondents, the petitioner may be permitted to cross-examine them. Stanza. The case of the petitioner is that under the service rules, the period of probation prescribed is 1 year, and since no order was passed extending the period of probation, and consequently he would be deemed to have been confirmed in December 2000, it is urged that the probation could be extended by a maximum period of 3 years, which expired in December 2003. Thereafter, his services would be deemed to have been confirmed. There was no justification in not confirming him in the year 2005 or in postponing the issue relating to confirmation on the ground that his services had not been found to be satisfactory. It is urged that the same mistake was committed when the respondent refused to confirm the petitioner in October 2007. It is further submitted that at the relevant time there was no adverse entry in preceding 5 years. The solitary adverse entry of the year 2001-2002, being an entry more than 5 years old, could not be made basis for not confirming the petitioner, and in denying promotion to him, the warning issued by the Registrar General by order dated 12/6/2007 also could not form basis for withholding confirmation or denying promotion to the petitioner, inasmuch as a warning is neither an adverse entry nor a punishment under the service rules. It is pointed out that a preliminary inquiry in another matter, which also formed the basis for denying confirmation, has culminated in favor of the petitioner, and thus the same could not have been the basis for denying confirmation in service of